Hello, I am Nicola Magrath, a family law solicitor at Andrew Isaacs Law Limited. I'm based in the Melton Mowbray office at Pira Business Park, and I am going to talk to you today about dividing assets and debts following the breakdown of the marriage and when you're going through the divorce and financial settlement process. So these are assets that have been acquired during the marriage or during the period of cohabitation prior to the marriage, and they include assets such as the family home, pensions, other properties, savings, investments, businesses, personal assets worth more than £500 for a single item, and can also include cars as well, and debts such as credit cards and loans. Some assets can be classed as non-matrimonial and ring-fenced, but this is very much dependent on the circumstances of the case. So what is considered for a financial settlement is different in each case, and it is very much dependent on the circumstances and the assets owned by the parties. So there is no one size that fits all. And this is why the courts have a wide discretion when making decisions about financial settlement. They will only approve an agreement or make an order which is fair and reasonable in the circumstances. And the starting point for this is what's called the sharing principle. This is when all matrimonial assets are divided equally between the parties, but it does not mean that they will be an equal division in every case. This is just a starting point, and the main consideration is the needs of the parties and making sure the needs are met based on the assets available. So there is not always an equal division, and it is very important to note, as it can be a common misconception, is fair and reasonable does not always mean equal. The important consideration is the needs and the circumstances of each party when deciding what division of assets could be. The first consideration is the welfare and needs of any children of the family who have not attained the age of 18, as their welfare is the paramount consideration. Other factors which the court consider includes the income earning capacity of each party, the property and other financial resources that each party has or is likely to have in the future, the financial needs and obligations and responsibilities of the parties, the standard of living that they enjoyed before the breakdown of the marriage, the age of the parties and the duration of the marriage, any physical or mental disabilities of the parties, and the contributions made by any of the parties. And one other factor, which is usually in exceptional circumstances, is any conduct of the parties. So not necessarily. There are various options available to parties. This is where they can negotiate and use solicitors to reach an agreement, a mediator, so they can instruct a mediator to assist them at mediation sessions to reach an agreement, or the last resort is through the courts, and this is where the courts will get involved and can make a decision on how the assets are to be divided. It is important to note, though, that if an agreement is reached either through solicitors or mediation, that agreement has to be drawn up in an order and approved by the court before it is legally binding, and the court will approve the order if it is fair and reasonable in the circumstances. So the first stage is usually for each party to provide full and frank financial disclosure to each other. So this information can be exchanged initially on a voluntary basis, and to see if an agreement can be reached this way without the courts being involved and making a decision for you. If an agreement is reached this way, then it can be drawn up by a solicitor in a financial consent order, signed by the parties, and then sent to the court for approval. As mentioned, I think with every question, the court will only approve it if it is fair and reasonable in the circumstances. So it's important to take this in consideration when reaching any settlement agreement. If an agreement is not achievable through voluntary disclosure, then there are other options such as mediation or through the courts, which is a last resort. And this is where financial proceedings are commenced. And then the court sets a timetable, lists hearings, and then the court makes a decision on how the finances and the assets are to be divided. So reaching a financial agreement following a divorce can be an extremely complicated and stressful situation for the parties. And we could be here to support you throughout this process, provide you with clear, tailored advice on your financial situation, and provide you with the various options. We are not a firm that push you to go straight to court proceedings, as we understand this is an expensive process, and we always try to look at alternative means first of all. So if you think that we can help you, contact us today to arrange initial fixed fee consultation, because your family does matter to us.